Welcome to today's edition of You and the Law. Today, we'll be looking at matrimonial proceedings, specifically dissolution of marriage, otherwise known as divorce. What is dissolution of marriage? It's a matrimonial proceedings initiated at the High Court to dissolve statutory marriage, which is marriage under the Act, as we had explained at the previous edition. What are the grounds for divorce under the law? Under Section 15 of the Matrimonial Causes Act, there is only one ground under which marriage can be dissolved. What is this ground? That section says that marriage may be dissolved if the marriage has broken down irretrievably. Note, if the marriage has broken down irretrievably, it means that that marriage is liable to dissolution. Under this ground, there are several factors that can give rise to a matrimonial proceeding for the purpose of dissolving a marriage. What are these factors? What are these grounds that are subsumed under this generic and omnibus ground of irretrievable breakdown of marriage? We have, number one, that since the marriage, either of the parties, the respondent, which is the person against whom matrimonial proceedings is initiated, has refused to consummate the marriage with the petitioner. The petitioner is the party that goes to court, the party that initiates the proceedings for the purpose of dissolving the marriage. Now, when a person alleges that the other party, that the respondent, has not consummated the marriage, what that means is that since the marriage was celebrated, since the marriage was entered into, the respondent has refused the petitioner, which can be either husband or wife, depending on who the respondent or the petitioner is, to have intercourse, sexual intercourse. Where either party refuses to consummate the marriage, that is an absolute ground to dissolve the marriage. Another ground for dissolving marriage is adultery. That since the marriage, the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. This means that, one, the petitioner who is going to court to have the marriage dissolved is alleging that the respondent has committed adultery. But in addition to that, the petitioner must also state that he or she finds it intolerable to live with the respondent. Meaning that where a party to the marriage has committed adultery and the other party indulges, excuses, or tolerates that act of adultery, that will not justify a petition for dissolution under Section 15 of the Matrimonial Causes Act. That party must also find that adulterous conduct intolerable. 3 is that the respondent has behaved in a manner that the petitioner cannot reasonably be expected to live with the respondent. The petitioner cannot reasonably be expected to live with the respondent because of the manner that the respondent has behaved. The fourth ground under which marriage can be dissolved, under the generic ground that I had earlier explained, immediately after the presentation of the petition, the respondent has deserted the petitioner for a continuous period of 1 year. This means where a party to a marriage has deserted the other party within 1 year, immediately preceding the presentation of the petition, that is a ground for dissolution. The fifth ground is where both parties have lived apart, or you can say where both parties have deserted themselves. The husband decides to live apart, the wife decides to live apart for a continuous period of 2 years, immediately preceding the presentation of the petition. That is also a ground for either the respondent or either the husband or the wife to proceed to court and file a petition for dissolution of marriage.